Well, thank you and welcome to Bankruptcy Training. I am your host, Crystal Jamerson, and I'm the Community Engagement Outreach Coordinator here for Legal Services of Northwest Minnesota. Today we have a very special guest, Cheryl Bergian from Cheryl Bergian Law Office, to bring you educational information about bankruptcy. As you know, this CLE will give you 1.5 standard CLE credits, and all proceeds from this fundraiser will go to LSNM so that we can continue to support low-income individuals in Northwest Minnesota with their civil legal needs. We also want to personally invite you to LSNM's bakery fundraiser that we're having. I'm just going to make sure I put that up there. And that one will be on February 13th, where we will have networking, sweet treats, and music. If for some reason you can't make it, but you still want to donate, no worries. You can always feel free to donate on the Giving Hearts Day website as well. And there's a QR code available that you can share. If you have any questions at this time too, and then also while Cheryl's presenting, please make sure to put all of the questions in the chat. There are also some informational documents in the chat that will help you along the way during the presentation. So without further ado, I want to pass the mic on to Cheryl.
Thank you. And so folks know the documents that are in the chat are actually the presentation documents. So please have those because the outline of the presentation is one of those. It's the first one titled When Financial Crisis is Looming. And that's the outline I'm going to follow today. I appreciate being able to do this. I am a legal aid attorney from way back. My first employment as an attorney in 1988 was with Legal Services of Northwest Minnesota. At that time, Northwest Minnesota Legal Services. So am very familiar with the work that you all do. I have a bankruptcy practice. I'm now located I'm in Fargo, North Dakota. Been doing bankruptcy, Chapter 7, Chapter 13 bankruptcies for debtors full-time since 2009. Have my own practice since 2012. And the debtor side of the bankruptcy is the work that I do. I've entitled the presentation When Financial Crisis is Looming so that as folks are talking to people who are under financial stress, having debt that is causing them problems, it would be possible to identify at what point bankruptcy might be necessary to relieve financial crisis and reduce financial stress, quite frankly. This is a small group today, so if folks have questions, if you prefer to just unmute and ask them, I would encourage that instead of having to type out a question. And please do ask any questions that you have as we go along. And actually, to begin the presentation today, I would like to know if anyone has any burning questions that they'd like to provide at this point, so I can make a note and make sure that I answer them as we go along. And of course, we'll hold some time to have questions at the end. And I didn't check the end time. If you could confirm it for me, it is, I think, 1:15 p.m. is when we
1:15,
end.
that's correct.
Okay, thank you.
You're welcome.
So, any burning questions?
I'll ask a
Ann?
question. Hi, this is Ann. And you maybe won't be answering this, but I think a big question for me as a legal aid attorney is when does bankruptcy make sense? And I know there's probably not a simple answer, but I am hoping you at some point hit that because we have low income clients, their income is protected. When should we be thinking about filing bankruptcy on behalf of those clients? When does it really, I mean, it always provides value, but when is it the most valuable? So we can put our resources where it makes sense. Does that question make sense, Cheryl?
Mm-hmm.
Okay,
Yep.
thank you.
Any other questions from folks that they want to make sure they get in at this point? And I'm not sure that I'm going to see chats, so let me know if there's a chat question as we go along. To answer that question of when is bankruptcy necessary, it really is necessary when it's needed to protect money or property. Bankruptcy stops debt collection. And so one of the things to be looking at when people are under financial stress is what stage do they have income or property property interests that they might lose to a creditor without the intervention of the permanent prohibition against debt collection. And it certainly is a situation where someone's income is protected. Minnesota has excellent income protection provisions for people who have been on any version of public assistance. And that continues for wages for a period of time, I think up to 6 months after public assistance has ended. And so it may not be necessary to protect income. However, sometimes people have a property interest that needs protection, and that would be perhaps if they're behind on a mortgage and it's necessary to file a bankruptcy to catch up on mortgage payments for their home and stop a foreclosure. So one thing that I do when I talk to people, and I see this most often when people are elderly, quite frankly, and their only income is Social Security, retirement, which is completely protected against a creditor being able to successfully take that from them by garnishment, either interception or garnished out of a bank account, or pension income. Actually, retirement income is protected also. It's a protected income source, protected when it's in a bank account. Creditors can attempt to take that, but they can never successfully get it. And then they have property that a creditor can't take. They may have a home, but they don't have enough equity in the home that the creditor could attempt to take their home from them. That would be very unusual. There's a very high exemption amount for homesteads in Minnesota. And their car is below the maximum that a creditor can take. So the phrase that I use when I'm talking to these folks is they are judgment proof. Now, creditors don't like that because judgments can be obtained in a collection lawsuit, and creditors can attempt to take money or property from people after a judgment is recorded, but they can't ever successfully take it. And that's the judgment proof part, and that's what I explain to people. So what bankruptcy does in those situations is it does stop collection hassle. And that is the benefit for those folks, is that it stops the phone calls, it stops the collection letters. And something to be aware of is that after a creditor has a judgment in a collection lawsuit, it's automatically a lien against any real property, including a home that is owned by the person who is the debtor in the collection lawsuit. And while the creditor cannot successfully force the person from their home because of the homestead exemption, which is around $480,000, it's very high in Minnesota, equity in a home. It would have to be paid for the person. That judgment amount would have to be paid for the person to transfer ownership, sell the property, or for it to be inherited after their death, so transfer after death. So that is a reason to do a bankruptcy, is to stop a collection action so it doesn't get to a judgment, or if it's already been a judgment, there's a way to remove that judgment from the state court records after the bankruptcy is completed. And then it removes that judgment lien. Judgments in Minnesota are collectible for 10 years, renewable for 10 more. So it can be a very long time that judgment lien exists when there's a home owned. And in Minnesota, also judgments can attach to property that is purchased after the judgment has been recorded. It's called after acquired property. And so that is another reason, if there might be a purchase or inheritance of a home or land otherwise, then that would be another reason to do a bankruptcy for those folks. But otherwise, it's only to stop collection hassle. So I'll start from the top of my outline, understanding bankruptcy options. The bankruptcies that individuals use are Chapter 7, 13, 11, and 12. 11 is a business reorganization bankruptcy. It is available to individuals, but generally the people who would need to be in that bankruptcy have very high debt, personal debt, and high income, so they don't qualify for a Chapter 7 bankruptcy. Chapter 7 is a bankruptcy where there's no repayment requirement. Chapter 13 is a payment plan bankruptcy, and some people are required to be in a Chapter 13 bankruptcy because their income is high. those folks, if their income's too much for the Chapter 13, or if they're other factors, there's some other factors to look at when there's high income and high debt. The Chapter 11 is available to them, and it's usually like dentists or physicians, so professionals that are in those individual debt situations where Chapter 11 is something to be looked at. Otherwise, it's businesses, business reorganization bankruptcy. Chapter 12 is for family farmers and limited to family farmers. Chapter 7, as I mentioned, is the bankruptcy where there's no repayment requirement. That's the chapter that most people qualify for, and it's the one that people are most familiar with if they know anything about bankruptcy. Chapter 13 is a payment plan bankruptcy. The households that are required to be in that Chapter 13 bankruptcy have income above the median household income for their household size in Minnesota. For a household of one, the median household income is $71,961. The numbers go up from there for larger household sizes. Dependents are included in those household sizes. So if you pay child support or support a child that doesn't live with you, that is a child that's included in that household size. I know legal services folks probably won't run into these situations, but that's the Chapter 13. Also, if someone has money or property they'd have to give up in a Chapter 7 that wouldn't fit in the exemptions, the amount of property that they can keep, Chapter 13 is an option to file so that people can keep that property. That comes up in situations where there's sometimes ownership of like a lake cabin, inherited lake cabin, sometimes recreational vehicles, sometimes high value life insurance policies, which is a little unusual to run into, but can happen. But some property interest that is more than the exemptions, and I'll review the exemptions as we go along. The next document that I provided, entitled the Bankruptcy Information Sheet, is a document that's provided from the bankruptcy court. It's required to be reviewed with my clients when I'm filing a bankruptcy. It's really helpful information, I believe, regarding some of the information regarding a bankruptcy. What bankruptcy does is it stops debt collection. So all debt collection, everything, telephone calls, collection letters, wage garnishment, collection lawsuit, everything is required to stop the date that the bankruptcy is filed. After the bankruptcy is filed, about 4 months later in a Chapter 7 bankruptcy, the order of discharge is filed. Order of discharge is that permanent prohibition against debt collection. The first part of the bankruptcy information sheet reviews the 4 kinds of bankruptcies that individuals use. Bankruptcies are in credit histories for as long as 10 years, can affect ability to get credit in the future. That is a very high concern for a lot of people. They're really worried that they'll never have access to credit again, think they'll never be able to get a car loan again, won't be able to get a mortgage. Sometimes are concerned about having a credit card for emergency expenses. And so I often talk with folks about the effect of bankruptcy in their credit history. While it's in credit history for up to 10 years, people can qualify for a mortgage 2 years after a bankruptcy is completed. So the bankruptcy is no longer a barrier to qualification for FHA finance mortgages, as long as people's income and down payment requirements meet the requirements for those. So people can access, be eligible for a mortgage 2 years after a bankruptcy is completed. It will affect the cost of the interest rate of a car loan for a number of years, although bankruptcy stops debt collection. So as time goes on, it actually helps improve credit histories, especially if people are making mortgage payments or already making car loan payments. They get reported into their credit history on time, and then that improves their credit history. Once they have debt that's gone into collection and getting reported into their credit history, their credit scores are already pretty low anyway. They have negative information in their credit history. So bankruptcy actually helps that situation. Otherwise, it would just continue. As far as access to credit cards for emergency expenses, I entirely understand that concern. Often when people talk with me, they've incurred debt, credit card debt, often for medical expenses. They paid their medical expenses, but needed to use their credit cards for living expenses, and they're very scared because they don't have extra income that they can put aside otherwise to save for that car repair or that home repair or daycare for children in the future, things like that. Having that available income for that. So one thing I talk with folks about when that's a concern is once they decide to move forward with filing a bankruptcy, they stop making payments on the debt that will be included in the bankruptcy discharge. They stop that, and I encourage people to start putting that money into a savings account after the cost of the bankruptcy is paid, so that they have that savings account as that emergency that emergency fund rather than relying on access to a credit card in the future. I'm hoping that can help people shift their thinking to anticipating emergency expenses and saving for them. Furnace repair, furnace replacement, which always happens when it's the coldest weather and it's an emergency expense. Car repair, anticipating increased maintenance costs for cars as they age, those kinds of things. Saving for the next car so they have a significant down payment, don't need as much of a car loan balance when they need to purchase the next car, doing those kinds of things. Encourage people to start thinking about when it's going to be time to replace the next car, start talking to friends and relatives and find that car that's being used by someone who had to quit driving. Often elderly. Talk to friends, relatives, coworkers, people at church, any connections they have. Find that car because those tend to be good cars, well maintained, lower mileage, and sufficient for a household with children as far as size. And those are great cars to purchase as used cars when it's time to look at replacing a current car. Next part of the bankruptcy information sheet talks about the bankruptcy discharge. That's the reason most people file for bankruptcy, and that is that permanent prohibition against debt collection. There is some debt that's not dischargeable. The bankruptcy information sheet says most taxes. Some income tax debt is dischargeable, some is not. More recent income tax debt is not dischargeable if tax returns have been filed last 3 years or so. Also, if tax returns have never been filed, income tax debt is not dischargeable, whether it's federal or state, but older tax debt is dischargeable in a Chapter 7, and there's a way to manage. That is another reason to file a Chapter 13 bankruptcy, because if that tax debt is not dischargeable, filing a Chapter 13, it gets paid in that Chapter 13 bankruptcy, and it stops the accrual of penalties for non-filing of taxes in the past. So it reduces that increase in that tax debt and then gets paid through the Chapter 13 bankruptcy. It's a priority debt in Chapter 13, so it gets paid 100% in that Chapter 13. Also non-dischargeable is child support or alimony, known as domestic support obligations. So if you have those obligations, they are not dischargeable, whether it's arrears or current amounts. It says most student loans are dischargeable in a bankruptcy. There's a fairly significant standard to meet. Requires a separate proceeding in the bankruptcy case called the adversary proceeding. Bankruptcy is part of the federal court system. And when we file the bankruptcy, we're actually filing in bankruptcy court as part of the federal district court. And those adversary proceedings are available. In the Biden administration, there were some streamlined options for discharge of student loan debt, whether it's federally insured student loans or private student loan. Well, federally insured student loans were the streamlined options. Adversary proceedings available for private student loans also. It remains to be seen what will happen to those streamlined options in the Trump administration. I anticipate that they will go away, but the adversary proceeding is part of the federal law. So that will be available, and the legal standard to be met, which is undue hardship, which has been interpreted generally so to be if that student loan debt would be unable to be paid in the lifetime of the person who has the student loans. And also that adversary proceeding is not included in the cost of the original filing. It is an extra cost. Can be a fairly high cost kind of process because everything is very individualized and fact-based, and the student loan providers fight those adversary proceedings, every single one of them. almost always because they don't want to get the case law established that makes it easier to rely on to get future student loans discharged. So that's been a very highly litigated area of law in the bankruptcy courts across the nation. Will that ever change where student loans might be included in the bankruptcy discharge, perhaps with some standards to be met? I thought that was possible in past administrations. It wasn't even proposed, I don't believe, during the Biden administration. It was proposed during the Obama administrations. It remains to be seen if that can be available at some point. I doubt it within the next 4 years. Court finds criminal restitution is dischargeable. Some debt owed to states is dischargeable. Some is not. That also there are a number of factors that can play into that, but overpayments of Social Security, federal government, overpayments of public benefits also can be dischargeable. There's some factors in that. Personal injury caused by driving drunk or under the influence also not dischargeable. One thing to know is that in a bankruptcy, the debt that is included in the discharge is the debt that exists on the date the bankruptcy is filed. New debt is not included, and it is not possible to withdraw a Chapter 7 bankruptcy once it's filed. So one thing I talk with folks about when they have medical debt is if their current income, if they're not trying to keep up on paying debt that will be included in the discharge, if their income is sufficient to keep up with current medical expenses. I do have some situations where people have chronic health conditions, cancer treatment, for example, where they're going to incur medical expenses that they cannot pay. They have a high deductible health insurance plan, for example. And so we're waiting to file their bankruptcy until their health situation stabilizes enough so that we are including in the bankruptcy discharge all the debt that will not be possible for them to repay in the future. And so they don't have that high medical expense going forward. It is possible to file a bankruptcy not having health insurance in place. I don't recommend it. And it is a high risk kind of situation because of that high possibility of medical expenses. And people cannot cannot get a discharge in another Chapter 7 bankruptcy for 8 years after a Chapter 7 bankruptcy has been filed, including a discharge. So that is a concern when there's going to be continuing medical expenses that are unaffordable. Other debt also, new debt not included, new credit card debt, that kind of thing. It is possible that a debt is not subject to the discharge if there is a adversary proceeding filed by a creditor or the trustee that says that some debt was incurred by fraud or received money or property by fraud. That is possible. It's an adversary proceeding in the bankruptcy, fairly unusual, but I have had it happen. I had someone who had a mental health problem and took a credit card from $0 to $7,000 on a weekend after having met with me and paid me to do the bankruptcy. That person ended up with an adversary proceeding. I advised her that debt would not be discharged. And that was unfortunate, but it does occur. The standard for fraud is incurring a debt without the intent to repay it. Most people, credit cards, they're trying to pay. They have paid for a long time. They're trying to pay. They make payments on the credit cards. They use the credit cards because they don't have the money to pay their living expenses, and so those credit card balances go up. It is very unusual to see a fraud issue as far as incurring debt. Medical can happen with some cosmetic procedures, tough for their creditors to prove, also for credit cards. Gambling is a situation where creditors in the past have tried to say that debt was incurred by fraud because there wasn't an intent to repay. But the reality is that most people who have gambling problems always believe they're going to pay their debt. They're going to win and pay their debt. So that litigation has not been successful. It's important to list all property and debt in the bankruptcy schedules. If it's not listed, it's possible it won't be discharged. It is possible for a debt to be discharged even if it's not listed in a no asset Chapter 7 bankruptcy. That has happened where debt has shown up after the bankruptcy is completed. included in the discharge as long as it was a no asset Chapter 7, meaning that there was no money or property available for creditors. Also, if there's a question of dishonesty in a bankruptcy case, then the debt may not be discharged, individual or all of it. Can receive a Chapter 7 discharge once every 8 years. Other rules apply for a 13. When people incur new debt after a Chapter 7, it is possible to file that Chapter 13 bankruptcy, that payment plan bankruptcy, 4 years after the Chapter 7 has been filed. And bankruptcy does not prevent debt payment. It only prevents debt collection. Many people incur debt to family or friends. That debt is payable after the bankruptcy is completed. So it doesn't prevent debt payment. People do have to list money owed to family or friends, to individuals, as well as money owed to businesses in a bankruptcy filing. And once the bankruptcy order of discharge has been filed, no one can make the person attempt to pay, but there's secured debt, and that is mortgages, car loans. People can keep that property. And I see the chat about the gamblers. I'll come back to that. People can keep that property, but they have to continue to make the payments. In a Chapter 7 bankruptcy, it's possible to modify some loans, not residence loans, but other kinds of mortgages and other kinds of property or car loans. It's possible to modify those in a Chapter 13, but not possible in a Chapter 7. So what has happened in the question regarding gambling is that people incur debt, either online loans, credit card debt, cash advances on credit cards, and they've used that money to gamble, and they've lost it. And so there have been adversary proceedings by those creditors in bankruptcy cases nationwide where they have asserted that the person incurred that debt without the intent to repay it. That when the debt was incurred, when they took out the cash advance or they took out the online loan, they intended to gamble the money and not repay the debt. And most of those cases, the creditor has not been able to prove that the person who incurred that debt, that cash advance or online loan, didn't intend to repay it, because people who gamble believe they're going to repay their debt. They intend to win. And so that intent not to repay element for debt that is not subject to the discharge because there was a fraud, intent not to repay, is not a finding that the judge could make. I haven't seen any of those cases. I watch for them though when I talk with people about that remote possibility when debt has been incurred by gambling, because part of the information in the bankruptcy case is gambling losses, and that's in the schedule, in the statement of financial affairs, one of the documents. It's part of the documents I've provided. So there are questions about gambling losses in the year prior to the bankruptcy being filed in the statement of financial affairs. Let me know if there's more information regarding that gambling issue. Someone has questions about. Sounds like not. So for secured debt in a Chapter 7 bankruptcy, creditors will want what's called a reaffirmation agreement. That is an agreement that is signed and filed signed by the creditor and the debtor and filed in the bankruptcy case. It reaffirms the personal liability on that secured debt. So for a mortgage, for a car loan, where there's secured property, the personal liability on that debt is part of the order of discharge. The creditor can never personally pursue regarding that deficiency balance if the loan is not paid. A reaffirmation agreement reinstates that personal liability no matter what happens to that property. It is difficult to have personal liability on a mortgage for a residence after a bankruptcy is completed. In a mortgage foreclosure action, it's difficult to have that personal liability. Very common to have personal liability on car loans, where the balance on the car loan is more than the value of the vehicle. For some reason, that loan is not paid off, change in household financial circumstances, vehicles as engine blows up, car is no longer drivable, and then that car loan still exists. That difference between the value of the vehicle and the balance of the loan is a deficiency balance after a car is repossessed. Creditors want people to sign these reaffirmation agreements because they reinstate that personal liability no matter what happens to the vehicle, that secured property. I recommend against it. I have no car loan creditors. People are so afraid of losing their cars. I have no car loan creditors who are going after repossessing vehicles after a bankruptcy is completed and a reaffirmation agreement's not filed as long as payments continue. These car loan creditors are not in the business of repossessing vehicles and selling them. They're in the business of reissuing new loans. Credit unions are the exception to that. Credit unions always want a reaffirmation agreement. They don't have to meet the standards that are in the bankruptcy information sheet. There's an exception for credit unions. They're pretty aggressive about wanting and saying that they will repossess a vehicle. But other regular car loans, like the big Ally and the big car loan creditors, they are not repossessing vehicles as long as payments continue. So I recommend against signing reaffirmation agreements because I want people to be in the best financial position possible. If that transmission goes out, if that engine blows up, if there's a change in financial circumstances in the household, I want my clients 6 months after the bankruptcy is completed to not have that personal liability on that car loan if something happens and they can't continue the payments. So that covers the bankruptcy information sheet. I have included as part of the documents that I provided the actual petition schedules and statements that are filed in the bankruptcy. As you can see, there's 58 pages here. Most bankruptcy filings, because we have to list all the creditors, most bankruptcy filings are 60 to 80 pages, often 80 or more pages. And all of these questions have to be answered by every debtor, whether the information applies to them or not. And financial disclosure is critical in a bankruptcy case. Saying no to a question is as important to say as saying yes in the bankruptcy filing. The schedule that is the property schedule, which is Schedule A/B, used to be separated. A was real property, B was personal property. They put them together a number of years ago and call it A/B. This is the property interest schedule, and every kind of property interest that someone has, whether they have an exemption that's available to protect that, is required to be listed in the bankruptcy filing. All bank accounts, retirement accounts, real property owned, including home, any vehicle ownership, all of that is included. Also, property interests like money owed to someone. So if they've lent someone money, or if there's a small claims court judgment against someone where they are owed money, the debtor is owed money, that is a property interest. People often don't think about that. Personal injury claims are property interest, may be protected in an exemption or partially protected in an exemption, but that is also a property interest. And also interest in inheritances. So if someone has died and someone's going to receive money or property, that is a property interest in a bankruptcy. Also, estate planning by family can transfer ownership of real property, farmland, cabin, to adult children is most common, with the parents keeping a life estate, keeping the right to use that real property and benefit from it. So income from the farmland, use of the lake cabin, that transfer, that deed where the adult children are the remainder owners, can be done without the remainder owners knowing that that deed has been recorded. It does transfer ownership of that property at that time as deed is recorded. I'm very careful to make sure that when I'm talking with folks that I ask if there's a possibility that any of their family has done estate planning. And I have run into that situation and run into it recently, where there was that transfer of ownership of farmland. If we had filed that Chapter 7 bankruptcy, the trustee who was assigned to the bankruptcy case after the filing would have had the right to sell that property, that farmland, that remainder interest in farmland, and that would have been lost to my client. The money would have been used to pay her debt. So bankruptcy was not a good option for that person, even though she had pretty high credit card debt. She and her mom, who is a life estate owner, are figuring out some options to try to settle that debt instead of doing a bankruptcy. So in a bankruptcy, income sufficient to pay necessary living expenses is protected in a bankruptcy filing. You do not have to give up that income. As I mentioned, wage garnishments stop once the bankruptcy is filed. That is a reason that it tends to be a financial crisis where it's necessary to file a bankruptcy to get that wage garnishment to stop. Chapter 13 plan payments are based on household income, less necessary living expenses. So if people have to be in a Chapter 13 because their household income is high enough, they have enough for necessary living expenses. Discretionary spending is very limited. And then the balance each month is their Chapter 13 plan payment and goes to the creditors for 5 years. Minimum 3 years if the bankruptcy is being filed because it's within 8 years of another Chapter 7, or 3 years if it's being filed because they have money or they have property they'd have to give up in a Chapter 7. And their income is below the requirements for a Chapter 13, then it can be a 3-year plan, any number between 3 years and 5 years. In those situations, 5 years if their income is above that median household income, and therefore they're required to be in a 5-year Chapter 13 plan. But the amount that's required to be paid is based on income and living expenses, as long as a guideline of at least 10% of their unsecured debt is paid over the 5 years. And the next part is the exemptions. That is property sufficient to maintain the household is protected in the bankruptcy filing. In an earlier legal table, there was a question regarding how do where's the resource to tell me if property is protected in a bankruptcy file, exempted in a bankruptcy filing. That is not an easy answer, unfortunately. Because exemptions in bankruptcy, especially in bankruptcy, are complex. There's 2 schemes of bankruptcy exemptions that are available. One is the federal exemptions, which are available in Minnesota. They're not in North Dakota. This differs state by state, state options. But there are federal exemptions, and then there are state exemptions, Minnesota. So the state exemptions that are available is the property that's protected against creditors generally in Minnesota. And that's the one where there's that very high homestead exemption. It is, how much is that? Oh, I think it's like 480,000. It's gone up, 510,000. And that's in a city. So can be even higher for farmland, which includes a home on the contiguous property. So that's that homestead exemption. That's the Minnesota exemptions. There are also federal exemptions that are available. The federal exemption for a homestead is $27,900. If it's a joint bankruptcy filing, 2 people can file a bankruptcy. If they're married, that's a joint bankruptcy filing. Financial information regarding both is included in the bankruptcy filing. Have to be married, legally married. Same-sex marriage spouses are eligible. And that homestead exemption doubles in that situation, so that would be around 58,000 or so for that homestead exemption. If the equity in their home is more than that, then they have to be in the state exemptions. And the downside to the state exemptions in the past was that household furnishings were protected, but there wasn't a protection for money in bank accounts, tax refunds that people would receive after the bankruptcy is filed. Wasn't an exemption for guns, which can be important in Minnesota, or no wildcard exemption for any recreational vehicles. The 2023 Minnesota legislature did do a lot of modifications to the exemptions, the Minnesota exemptions. They added a wildcard exemption, bankruptcy only, for money that's sitting in a bank account. However, the wildcard exemption under the federal exemptions can be much higher. Can be $15,000 for an individual, $30,000 for a joint bankruptcy filing, depending upon how much equity there is in the house. It's a sliding exemption based on how much of the homestead exemption is needed to be used. And so usually for most people, using the federal exemptions in bankruptcy is better because you get some wild card for that money sitting in a bank account, tax refunds that are going to be received after the bankruptcy is filed. This time of year, if I'm filing a bankruptcy now, it'd be the 2024 tax refunds that people will receive after their tax returns are filed. Also for guns and for things like recreational vehicles, multiple vehicles. There is a vehicle exemption. That vehicle exemption under the federal exemptions, and these change every 3 years also, the vehicle exemption for equity in a vehicle is $4,450. One vehicle, individual filing, two vehicles, depending upon ownership somewhat. In a joint bankruptcy filing, the vehicle exemption under the Minnesota exemptions is actually $10,000. So a much higher vehicle exemption, which could be important depending upon value of vehicles. Household furnishings are protected, pretty high exemption, about $13,000, $14,000, almost $15,000 now for that. And then there are exemptions. There is an exemption for any money sitting in a retirement account. That is essentially unlimited unless it's inherited. Inherited is not exempt in a bankruptcy filing. And then that general wildcard exemption. I really cannot point to any useful resource for determining whether someone's property would be protected when there are any property ownership that's unusual and not necessary to the maintenance of the house. So recreational vehicle, for example. And that's why I just can't say without actually doing that analysis whether someone can keep everything that they have. My practice and the practice I know of the bankruptcy attorneys in the region is to provide an initial financial assessment where we review all property interests that someone might have and confirm that they would be able to keep all the property that they have. If they rent and they have just household furnishings, yes, they're going to keep everything they have. If they rent and they have household furnishings and a car that's worth less than $5,000 or equity less than $5,000, yes, they're going to keep everything. The value of property in a bankruptcy, household furnishings, car, is private party value, so willing buyer, willing seller. So it's not replacement value. It's if you wanted to sell something, what would you get for it? So that, most people who are of limited income are not going to have property that they have to give up in a bankruptcy, but making sure that there's none of these unusual kinds of assets, inherited property, something like that, is the one thing to be watching out for. There are online resources. I shouldn't say online resources. There are some resources available that are like attorneys have on their websites, worksheets or workbooks that people have to fill out. And those can be helpful for guidance as far as the kind of property interests that have to be disclosed in a bankruptcy filing. I don't use worksheets or workbooks. I prefer to use the underlying documents when I'm working with folks. So I'm unusual in the bankruptcy world as far as not using those worksheets and workbooks. I do offer a free initial telephone consultation to anyone who needs and legal advice in the areas of practice that I do: bankruptcy, estate planning, probate, guardianship. And part of that initial telephone consultation is confirming that people would qualify for a Chapter 7 bankruptcy, they'd be able to keep everything they have, and the question of whether they might be judgment proof and whether bankruptcy is really solving a problem. A lot of people are really afraid that there's going to be a judgment and that they're going to have their wages garnished or their Social Security income garnished. And so I can talk with them about what that would mean. Even in a wage garnishment, there's protection for a base amount of income, but wage garnishments definitely, bankruptcy is probably going to be necessary unless the amount owed is pretty low. So the next part of the presentation is recognizing financial crisis. So there's financial stress and there's financial crisis. Financial stress starts when people are carrying credit card balances. They tend to make, they pay on their credit cards, make at least the minimum payment, more if they can, but those balances go up because then they're using those credit cards for living expenses, for groceries, for gasoline, and then medical expenses. A medical debt is definitely a financial stress. And, I see it in these high deductible plans. I also see it with families with chronic health problems, where they're, meeting those deductibles every single year and not able to save to pay those deductibles with the income they have, because when there's health problems, there's often a reduction in income. When people are doing online loans, that's definitely financial stress. And then when collection lawsuits start. One thing to know about collection lawsuits are started by service. Summons and complaint, process server, or sheriff's deputy can be served by mail if people sign for it. It's unusual for collection lawsuits to be started by mail service, but it is possible. And people don't realize that once that summons and complaint has been served, that's the start of the collection lawsuit. There's no court hearing scheduled. And they think that they have to have a court hearing before there's a judgment. And it is possible for a collection lawsuit to proceed, to be filed with the court system and proceed without a court hearing ever being scheduled. Motion for default judgment after the service of the summons and complaint, people receive that, and they think that they're going to get a court hearing, and they wait for that, and the judgment ends up being filed without that court hearing. So that is one thing that I talk with people about when I'm figuring out what stage their debt is at. Have there been collection lawsuits started? Is there a possibility of a judgment having been filed, recorded? Once that judgment is filed, it is possible to garnish money in a bank account without notice to the judgment debtor. It is also possible to garnish wages. Notice before wage garnishment has to be sent, by the way, after notice before wage garnishment can start in about 3 weeks. So that is definitely a stage where there's crisis. And so at that point, determining whether bankruptcy can be filed is going to be pretty important for those households. One thing I do when people have collection lawsuits is when they've been served with a collection lawsuit, I talk with them about the way that a creditor knows where they have a bank account is they're still making payments out of an account. So that's how they have made payments to that creditor from an account that they're still using. So that's how that creditor knows where they have a bank account. So if that has happened, they don't keep money out of that account as much as possible. Open an account at a different bank, move automatic deposit of payroll into that account, make payments out of that account for living expenses. That can avoid that garnishment from a bank account after a judgment has been filed. Wage garnishment, the creditor has to know where people are employed. I've always been suspect of the medical providers because I know, and maybe there's a reason for this I don't know about, but I know when I go to my medical appointments, annual physical was just earlier in January, they always ask where I'm employed. They don't just ask for health insurance card. They ask where I'm employed. And I've always wondered why that has to be part of my medical record. I don't know. It does give them that information though. Financial crisis. Mortgage foreclosure is the other one. When people have gotten behind on their mortgages for their homes, it's possible to file a Chapter 13 bankruptcy to catch up on those past due mortgage payments, those mortgage arrears. The difficulty in those financial situations is that people have to be able to pay their current mortgage amount, their current living expenses, and a plan payment that will pay those mortgage arrears over 3 to 5 years. And when people have been in financial stress, reduced finances, reduced income, that is often a difficult standard to meet for the confirmation of a Chapter 13 plan. I did include the Chapter 13 plan as part of the materials. That's the national plan. It's not actually the plan that's used in Minnesota. Minnesota has its own plan. North Dakota has its own plan, but it has the elements of what a Chapter 13 bankruptcy looks like as far as the information for that. And we've now hit the end of my presentation. We have a lot of time left. So I guess I will open it for questions.
Cheryl, it's Ann again.
Hi.
Ask another question. Um, from beginning to end for a chapter 7, how long does it take? I know that's a big question, but
Well, it's not so, it's a common question. So um, there are two parts to the answer. One is the part working with me to get the bankruptcy information prepared. And the second part is once the bankruptcy is filed to the order of discharge. So the first part, once I've had an initial telephone consultation, I think this works for most of the bankruptcy practices. Once we've done that initial consultation, the next step is, for me anyway, is scheduling the financial assessment appointment. I do those in person or by video. I think other firms, what they do is they send out a worksheet or workbook, have people fill that out, and then they review that. That's their financial assessment appointment. The information that's included in the financial assessment appointment is all the information, the financial information that's required for the bankruptcy filing. So income history, last 2 years of tax returns, 6 months of income history for any income received by the household, whether it's taxable income or not. Information regarding current monthly living expenses, and then information regarding all property interests. So bank accounts, bank account statements, retirement account statements, basic information regarding household furnishings, household electronics, information regarding ownership of any land, including residence. And this would include for residents, property tax statement, note, mortgage statement, car loan statements, car loan contracts also included. Financial disclosure for a bankruptcy is tough. And then the last part of the information in the financial assessment appointment is the information regarding all debt. So we've already done secured debt on the mortgage or car loans. And so credit card statements, online account statements, online account contracts, more billing statements for medical debt, any other kind of collection letters, collection statements. So all that financial information is required. I'm required to have those documents to prepare the bankruptcy itself, the schedules, Schedule A, B, and the Statement of Financial Affairs. And so what I do during the financial assessment appointment, which is scheduled about 3 to 4 weeks after my initial telephone consultation, what we're doing during that, they've provided all those documents and we're meeting and reviewing that. Income shows up in 3 places in the bankruptcy filing. Current monthly income, so that's where I work with pay stubs or other income to figure out what current monthly gross deductions and net is. People often know what their net paycheck is. Gross per month is required deductions and net per month. And then income history, 6 months income history, and then tax returns, past 2 years of tax returns. We also review the monthly budget worksheet. That's important. It's needed for the Chapter 7 bankruptcy filing. It's not reviewed by the bankruptcy trustee. It is reviewed in a Chapter 13. But I spend quite a bit of time with folks on that monthly budget worksheet because I want them to get a handle on what their actual monthly living expenses are, especially those recurring expenses that are harder to anticipate. So things like car repairs in the next 2 to 3 years. What do you need to be, putting aside if you need to plan for that? Some kinds of things like food, people really have a tough time knowing what they actually spend monthly for food. And we've entered a time of as part of this century, and it will continue, where these food delivery services are very common, pretty high cost kinds of things. Convenience foods, there's all sorts of costs related to convenience foods, whether it's a chopped up vegetables at the grocery store. I'm old. I grew up in a time when we went to the grocery store. We knew what our grocery bill was. We went to the department store. We knew what it cost for clothes. Now people go to Walmart or Target and everything's all mixed together. And so getting a handle on all those monthly expenses so that we know what their net monthly income is per month. It's required for the bankruptcy filing. And then we know what their monthly living expenses are that are necessary to maintain the household. And then we also know what discretionary spending has been occurring. To try to help people to feel as if once a bankruptcy is completed, they know where their money is going to go. It aligns with their values, it aligns with their goals, and it lets them have that extra at the end of each month so that they can have that money put aside for savings, for those emergency expenses, for the travel, the holiday travel, the kids' birthday gifts, the kids' Christmas gifts, grandparents or grandchildren's gifts, all those kinds of things. So financial assessment appointment about 3 to 4 weeks after initial telephone consultation. What I do during the initial telephone consultation, I provide that for free. We review why they're thinking about bankruptcy. I go over the kind of debt that folks have. They don't have to have everything at hand at that point. They just need to have information. And they know almost all this. I confirm that they qualify for bankruptcy. You qualify for debt relief if you're unable to pay your debt as it comes due. And then I review the kind of debt they have to make sure that they have dischargeable debt, to talk with them about if there's going to be debt like student loans, it will be not dischargeable. So they're prepared for that. Or other kind of debt, if there's tax debt, for example, that may or may not be dischargeable. I review with them their income, because I'm going to determine whether they can qualify for a Chapter 7 bankruptcy or if we need to be talking about a Chapter 13. Even if they're above the median household income, they can qualify for a Chapter 7, but there's a means test analysis that looks at actual living expenses. And some people that are over the median, they come back into the Chapter 7 because they have high medical expenses, high commuting expenses when they live out of town, travel to come into town every day, things like that. Daycare expense is another one that can pull people back into Chapter 7. So the possibility of a means test Chapter 7, which has an extra step in the analysis after the bankruptcy is filed, or if we need to be talking about Chapter 13, or if there is a reason to do a Chapter 13 because they have property they have to give up in a Chapter 7. And then the next part of the analysis in my initial telephone consultation is confirming that they'd be able to keep everything they have in a Chapter 7. And if that's so, talking with them about the cost of the bankruptcy. Now, the cost of the bankruptcy, minimum is going to be $1,500 for me for attorney's fees, $338 for filing fee, and going up from there, depending upon the amount of information that's required for the bankruptcy filing. When people have self-employment income, there's more information required in the bankruptcy filing, and that includes the gig economy. So then you're going to be above that $1,500 plus $338 for the filing fee. The other kind of extra information is when there's reaffirmation agreements, because I have to review with my clients the question of signing a reaffirmation agreement, depending upon whether it's credit union or other kind of creditor, and the effect of that and things like that. So there's more time. Most of us flat fee our bankruptcies. Most of us are going to be in the same kind of cost in this region as far as the cost of getting a bankruptcy filed. So at the end of the telephone consultation, I am generally able to tell them what would happen once a bankruptcy is filed, let them know that they'd be able to, if they move forward with getting a bankruptcy filed, scheduling a financial assessment appointment with me for that review of documents, that they can stop making payments on the debt that will be included in the bankruptcy discharge and start relieving some of that stress. The telephone calls from the creditors, the collection letters don't stop until the bankruptcy is filed. Although if they schedule a financial assessment appointment with me and pay any part of the cost of the retainer, the cost of the bankruptcy, retain me to file for bankruptcy, they can tell a creditor that's calling them that they've retained my office to file for bankruptcy, started the process of getting a bankruptcy filed. That creditor calls here, collection. It's usually the credit cards who are calling, sometimes medical debt collectors, but usually credit cards. That debt collector calls, whether it's a credit card or a debt collector, calls here, confirms I've been retained and stops calling them. Because those creditors know spending more time trying to call them to get them to continue to make payments is no longer useful use of their time, so they stop calling them. They can move forward with any other collection action, starting a collection lawsuit, continuing to send collection letters until the bankruptcy is actually filed with the court. Financial assessment appointment is a review of all the information for the bankruptcy filing. If they can pay the cost of the bankruptcy at that financial assessment appointment, we schedule the appointment to file the bankruptcy. That's going to be at least 6 months after that financial assessment, or not 6 months, 6 weeks. Okay. 6 weeks after the financial assessment appointment. I'm running about 2 months right now. between financial assessment and filing, the way that my schedule is. I'm not scheduling initial telephone consultations to practically April right now. They're scheduling at the end of March. Someone calls here and says, I need to do a bankruptcy. My legal assistant tells them initial telephone consultations are being scheduled and the earliest is this. And I require that initial telephone consultation in order to move forward. So I'm a sole practitioner with one legal assistant. I have capacity. So other firms have more staff, more attorneys. They can have a higher capacity than I do. And we do refer people who are in when they have a wage garnishment, something like that. We do refer to those other firms so they can get a bankruptcy filed more quickly. So once 2 months or so after the financial assessment appointment, bankruptcy is filed. Chapter 7 bankruptcy between filing and order of discharge is about 4 months. The only thing that happens between that is there's a meeting with the bankruptcy trustee. It's called a meeting of creditors, also called a 341 meeting. Creditors can attend. It's very unusual for creditors to attend. The meeting with the trustee is held by Zoom. Debtors are sworn in. The meeting is recorded. I do attend that meeting with them. It's part of the cost of the bankruptcy. I can't provide information for them other than if they completely blank out, I can say what's in the bankruptcy filing, but they have to answer the question of the trustee. Chapter 7 trustees' responsibilities are to confirm there's no material non-disclosures in the bankruptcy filing, also to confirm that there's no issues of dishonesty in the bankruptcy case. Those meetings in a Chapter 7 bankruptcy are scheduled to last 10 minutes.
Oh.
10.
I didn't realize
Trustees
that.
ask the same questions in all bankruptcy cases. Most Chapter 7 bankruptcies, there's no information they need to follow up on. Some of them, there's non-exempt assets, say a second car that we couldn't protect in an exemption. They will administer that car. They will take possession of the car and sell it. But they still aren't an extensive inquiry in the meeting of creditors, a 341 meeting, unless people can answer the questions. And the questions are confirming ownership of significant property, confirming income, and confirming some information in the statement of financial affairs, confirming that people haven't borrowed money from family members and been paying them back in the year before the bankruptcy is filed, because that's a preference. It happens very often at tax refund time, where someone's borrowed $2,000 for a car repair 6 months ago. Tax refunds come, they pay that family member back $2,000. They file the bankruptcy 2 months later. That $2,000 is the amount the trustee can get from that family member. It's called a preference. Something I screen for in my initial telephone consultations. Have you borrowed money from friends or family? Because people don't think about friends or family as creditors, but they are creditors. And then have you made payments to them? Because I want to avoid that preference issue or let them know that it exists if that has happened in the year before the bankruptcy is filed. If that has happened within the past year, my clients can opt to wait to file their bankruptcy until they're past that 1 year preference. If it's a very large preference amount, say it's $5,000, the trustee still can pursue that up to 4 years. So disclosure of that payment were made within 2 years. 1 year is the preference, and it's very easy for the trustee to recover those preferences. That's an action against the family member for that preference amount, but most often the person who's filed the bankruptcy wants to pay that if they possibly can, because they don't want their family member subject to a collection action in the bankruptcy case by the trustee. Trustee's income comes from administering non-exempt property or preferences, so the trustee has a financial incentive to pursue those on behalf of the creditors. So meeting with the trustee happens about 5 weeks after the bankruptcy is filed, always held by Zoom, recorded, sworn in. Order of discharge is no sooner than 60 days after that meeting. So 4 months from filing to order of discharge.
That's really helpful. Hey, there is a question in the chat. I didn't wanted to share it with you since I'm unmuted here. Someone asked, can you talk about the required financial counseling and education, and do you see it as helpful for folks?
Some people, so the pre-bankruptcy credit counseling course is required under the bankruptcy law. Content is determined by the U.S. Trustee's Office. Pre-bankruptcy credit counseling course, always online. No local providers do that anymore. Can be done by telephone. it duplicates the pre-filing course, duplicates what I do during the financial assessment appointment. It reviews the debt that people have, their income, their property interests, and confirms that debt relief is necessary for them. It was part of the 2005 bankruptcy law changes. Some people, even though they've done the appointment with me, find that assessment helpful for them as they're moving through stopping making payments on credit cards, which can be very difficult. By the way, people are very shamed by the credit card companies for not making payments on their credit cards. I have zero sympathy for the credit card companies other than they do provide my income, a good portion of my income. However, there is not one credit card company CEO that's sitting in a bankruptcy attorney's office and looking at the financial crisis that credit card company is in. They are incredibly profitable companies, and they incentivize people to incur more debt. When people are struggling with debt, they know it. They offer them more and more credit cards, and they encourage them to incur credit card debt and carry balances. The most profitable person for these credit card companies is a person who's carrying a balance, paying a high interest rate, using those credit cards for living expenses because they get the fees from the merchants. And most people, once I've talked to them, have made payments to these credit cards so that those credit card companies have long received what they loaned that person for whatever was purchased, and they have received a fair interest rate for those items. So our economy is built on, we are a capitalist economy. It is built on people buying things. Bankruptcy helps the economy. And I talk with people about those factors because it keeps people, that shame keeps people from filing for bankruptcy when it would have protected assets. I talk to people who've used their money in their retirement accounts to try to pay their debt. That is money that was protected in the bankruptcy filing, would have been for their future, would have kept it for their future, and those credit card companies did not need it. So I have zero sympathy for them. Anyway, here's a little side note. So the credit counseling course, when people are reorienting, stopping making payments on the credit cards, getting over that. I also, while I understand the medical providers need to be paid, they had an option during the run up to the Affordable Care Act to get on board stronger. At that point, we would have had a healthcare system that would have provided them a fair income for the services they provide. They did not get in place as early as they should have. And we are in the situation we are today because there is so much of the money that's paid to these healthcare providers that is paid to provide insurance claims all over the place, multiple administrative costs that could have been avoided had we had an Affordable Care Act that worked like in other countries, where we would have provided access to healthcare that is fair and then it is a human right. But they didn't do it. They can get on board, they can figure it out, they can put the pressure where the pressure is due. And so I am not wholly sympathetic to the medical providers also, because they have some options and they've had some options. Okay, so credit counseling. I know people have stopped making payments on the debt, or will stop or have stopped making payments on the debt that will be included in the bankruptcy filing. So credit counseling can help them in getting used to their income and their living expenses. The post-filing debtor education course, also called financial management course, is a budgeting course, and that people can find helpful because the stress of the debt is removed, the bankruptcy has been filed. That debtor education course has to be done within the 4 months between filing or an order of discharge. If that certificate is not completed and filed, that course is not completed and the certificate filed, they will not get the order of discharge. It's something we watch very carefully because I do not want to do all the work I've done for someone and not have that discharge. So, okay. So that can be helpful for people. It also is that sigh of relief. My income is mine. And then it helps them with getting used to their living expenses, knowing where they have some choices, if they have some choices. And I've done budgets where I've looked at them and I thought this is going to be really tough for this family. But it is what it is in the society that we have. So sometimes it's helpful. Sometimes you feel like it's a waste of time. The pre-filing credit counseling course, also a certificate that's issued to file in the bankruptcy case. They're required to spend 90 minutes doing that. Post-filing debtor education course, they're required to spend 2 hours, no matter how much time it really should take. So time they have to do, and the cost of those can be, I think the lowest I've got for the pre-filing course is $15. Post-filing, I think the lowest I've got for the cost of I have for that is $7 from the providers that are authorized from the bankruptcy court. And I did open the chat, so I see their fee waiver. There is a fee waiver for the bankruptcy filing fee. People have to meet the requirements. The information's on the bankruptcy court website. People have to meet the requirements. That's might be 150% of property. However, if an attorney is being paid, it's going to be really difficult to get that fee waiver. And I know the bankruptcy judges look at those fee waiver applications very carefully. The Chapter 7 trustee gets $60 of that. It's the only fee that the trustee receives in a Chapter 7 bankruptcy if there's no non-exempt property, no preferences, so no property for the trustee to administer. And probably about 80% of the cases in Chapter 7s are these no asset Chapter 7s where the Chapter 7 trustee is paid that $60 for all the time that the trustee and the trustee's office puts in for reviewing. So I know those fee waivers are very closely reviewed.
Perfect. Do we have other questions for Cheryl?
I do, Cheryl. Thank you for all the information. It's been great. Can you talk a little bit about situations where perhaps there's more than one household living in the house and the person filing bankruptcy is, the owner, and maybe they share expenses, that kind of thing? How does the income of the non-bankruptcy household affect now the person that's going to file bankruptcy? Maybe an adult child lives with them, that kind of thing.
Okay, so if people are married, spouse's income is required disclosure in a Chapter 7 bankruptcy, even though only one of the two spouses is filing. So marriage, that is required. It is a factor in the Chapter 13 means test, the test for the income available to repay in a Chapter 7, but that's only for married. When people are living with significant others, the extent to which the significant other's income pays for the living expenses of the person who's filing for bankruptcy, that is in-kind income in a bankruptcy filing. And I run into that. I talked to someone recently where the person's a stay-at-home mom living with a significant other, joint children. So the significant other pays all the expenses of the household. So the expenses that my client would have to pay if she were supporting herself and her children, so it would be, whatever it would cost for the, say half, I think in that situation, the significant other owns the home and has the mortgage. So for example, I would say half the mortgage, half the cost of food for the household, half the utilities, those are in-kind income for her. As far as the bankruptcy filing is concerned, it's going to be very unusual for that to create a means test issue because that income is just not going to be high enough to get you up to that, $100,000 for a household of three, or it's actually more than that, $120,000 for a household of three is the median in Minnesota. So very tough to get to that level just on in-kind income. If there are others in the household contributing to living expenses, whatever they contribute, say they pay half of the utilities, that is also an in-kind income included in the income history and income available to pay the expenses of the household when the mortgage is in the filing person's name.
Thank you.
Mm-hmm.
Do we have any other questions for Cheryl at this time? If you want to think about those questions, What we'd like to do right now, really quick, is to show you a resource just in case you do have any clients that maybe you're not able to assist or that just has some other extra questions and they'd like to find out of those resources on their own. There is always lawhelpmn.org. We always like to make sure that people are aware of where they can go to be able to find resources to help them out as well. When you go to lawhelpmn.org, you can always go to the self-help library or you can go ahead through the guided tour. But for today, we'll just show you where to go on the self-help library. You'll click on self-help library, and then there's a variety of topics that you can choose from. And today we would be choosing the money, debt, and taxes. From there, there's a couple of other options that we have. And today we go under bankruptcy. Scrolling under bankruptcy, they're going to give you a couple of different resources when it comes to dealing with debt. The nice thing about Law Help MN is that they're available in different languages, which is really, really helpful dealing with the multitude of clients that we have. They also have an additional helpful resources, bankruptcy tools, legal rights during and after bankruptcy, and then the U.S. Bankruptcy Court information. This is a very, very helpful tool for anybody that's just trying to find a little bit of information and maybe you have not met with an attorney, or if you're an attorney and you want to give your client just a little bit of information prior to going into bankruptcy. Just wanted to make sure that I share that resource with everyone because it is pretty important. If for some reason you are not a Minnesota resident, you can go to lawhelp.org and choose the state that your issue is in, and then you'll be able to see all the resources available for Law Help. So I just wanted to make sure that I shared that information with you, as that's pretty important. And I wanted to also open up the conversation if anyone had any further questions for Cheryl, or Cheryl, if you had some other tips, tricks, or thoughts.
Actually, if you'd bring that Law Help Minnesota up again. And Ann
Sure.
knows this. There's an option to ask questions and to choose the topic consumer and debt, I think it is. And if you would come to money, debt, and taxes, and I'll come back to that. But if people ask those questions in that category, I have a personal goal of always clearing those questions. So I answer them for people statewide. Debt collection and garnishment, if you'd go to that one. So when people ask questions in that part of Law Help Minnesota, I have a goal to keep all those questions cleared as much as I can. So it's just my little pro bono time because it's usually pretty easy for me anyway. And then I use in my answers to the questions, I point people to these areas. The debt collection rights, garnishment in your rights in repossession, all these areas, and in the money debt part of the Law Help Minnesota, I use these resources all of the time. And if you go to garnishment and your rights, that's third one down, second one. Here's where some of the exemptions issues are. And last time I looked, this was not updated for the current, but it might be now for the more recent changes in the garnishment exemptions where they made the Minnesota changes. But this is based on the Minnesota exemptions that I referenced with the $10,000 vehicle exemption. The wild card is not available under the Minnesota exemptions when creditors are attempting to take money or property, but they are available. It's an odd quirk when they pass that for bankruptcy filings. Wild card is $1,500, and it's only for money sitting in a bank account. So I just wanted to mention those two things.
No, that's perfect. Another thing that we like to look at, Law Help is just filled with so many different resources, and I absolutely love it. If you are a lawyer, it's great. If you are a client, it's great. It's just, and also one of the other things is that it's nice because you can translate that. That's just huge. And you can also just search. So if for some reason you weren't exactly sure where the help is, you can just search it and type in anything that you're looking for, and it's going to bring you up to the most recent or most relevant idea. Also, one thing while we were searching, oops, sorry, close, is that when we were in and Cheryl was talking about when it was last updated, one thing to look at is it will let you know when the last update was,
Okay.
which is really huge. Because if we do have some new laws that have come into place, it's really important that if this wasn't the last update or if it looks pretty old, to make sure to contact Cheryl, Legal Services of Northwest Minnesota, that we're able to help you out and maybe give you the right information at that time. Perfect. I'll stop sharing my screen unless there was one other thing that you wanted to look at on Law Help.
No, this
All
is a
right.
terrific resource.
Perfect. Okay. I'll just check the chat really quick to see if there's any last minute questions. Alrighty, well, I will share this last screen here. Do, do, do. So today, I just want to thank Cheryl for taking the time to explain bankruptcy to us. I also want to thank the audience for the questions and the participation. Really great questions. If you have any further questions for Cheryl, or for Legal Services of Northwest Minnesota, please feel free to reach out to our organization on the websites. Both of our websites are listed below, and yeah, you guys have most of the information here that's in the chat with all of the different documents. If you would like any of the documents sent to you, you can feel free to let me know in the chat before we leave, and then I'll go ahead and get those things forwarded to you as well. Just a reminder, this is worth 1.5 CLE credits, so you will be receiving an email with the number that you can use to be able to get your CLE credits as well. If there's nothing else, I will go ahead and end it for today. And I appreciate everybody for joining us and coming on in.
Thanks, everyone.
Thank you. Have a wonderful afternoon.